We have to cover this story, Culture, because I don't know if you saw this one, but a lot of people are looking at this with keen interest. What am I referring to? I'm referring to copyright surrounding Disney's big character, that being Mickey Mouse. Here you go from That Park Place. Morgan and Morgan suing Disney over Steamboat Willie public domain rights. Is Mickey Mouse, quote, for the people now? This by Ron E. Bradley of All the Bradley's Fun. Definitely check him out. September 26, 2025. Here we go. Law firm Morgan & Morgan wants to use the first iteration of Mickey Mouse, Steamboat Willie, in their advertising. In a preemptive strike, they have filed a lawsuit against Disney to ensure the House of Mouse doesn't come after them for copyright infringement. The suit was filed at the U.S. Middle District Court of Orlando, Florida on September 17th, 2025. And this move came around after the firm reached out to Disney to clarify whether they could use Steamboat Willie. Disney's response was short and dismissive. Quote, "We don't give legal advice to third parties," they said. Oh, really? Okay. With that, Morgan & Morgan is now seeking a court ruling that this particular version of Mickey does not infringe on Disney's intellectual property rights. This is an open question, Culture, as to what can you use in terms of the Mickey Mouse copyright or the Mickey Mouse trademark. Obviously, you have the iconic three circles, right? But we've seen Disney go after some people because of that. What can you use? What can't you? I think this is a pretty big deal that isn't getting a lot of attention right now, obviously, with the heavy news cycle. Culture, your immediate thoughts on this story.
I am not a lawyer, okay? I will admit to that right now. I'm not a lawyer. I've dealt with a lot of contract law and other associated things. But I'll say this. There is going to be a discussion about a difference between a trademark and a copyright. And that's where right. I think that this particular issue is going to get torn asunder. I think that Morgan & Morgan is looking for clarity, and that's good for them. I think that they should. But at the same time, we've had people get claimed for running this animation, which at this point in time should be freely available to everybody in fair use. Yeah. And Disney has been able to muddy the waters by taking Mickey Mouse and trademarking him. So we're going to see if you can get around copyright with trademarks. We'll see.
We will see. I mean, I know people were trying to play the original Steamboat Willie animation, and the copyright claims came a flowing right there, even though it should be in public domain. People should have access to this freely, and yet they don't. And then we've seen a number of parodies created. We've seen like video games actually utilizing iconic imagery from Steamboat Willie. Specifically, got that Steamboat Willie version of Mickey Mouse right there. So like you do have people dabbling in this, but I think there is an open question, especially for people who maybe want to make that product or want to invest in that product, just how far the mouse, that being Disney, is going to go in protecting, ironically, the mouse. I really don't know. Here you go. Anyone familiar with Morgan & Morgan, this from Ron Bradley right here, knows their famous marketing catchphrase, for the people. Ironically, that's exactly what the firm is arguing Steamboat Willie has become, for the people. Let's go ahead and bring on somebody who might have a little bit more to say, specifically the author of this article, Ron himself. Hello there, for all the Bradley's Fun. What's going on?
Hello. Good morning.
Good morning.
That was an interesting... interesting lawsuit situation where Morgan & Morgan literally reached out to Disney to ask, it's in the public sphere now. Disney no longer has the copyright to specifically Steamboat Willie. Morgan reach out, and Disney shuts them out and says, "We don't offer legal advice." Like,
well, they're looking like they're like they don't want to let this go. I think they want the ambiguity, Ron, because they know that if anybody steps over the line, in which they can kind of sue over, that being iconic imagery and so forth, I think it's like, we're going to go ahead and go after them. Like Culture said, it's not about not necessarily copyright; it's about trademarks and everything else. But go ahead, Ron.
I agree. It's just they still hold the copyright trademark to Mickey Mouse in general. Steamboat Willie is quite specific, and I can understand the company wanting to differentiate between something that is actually theirs and then something that is being represented as being from them, but not actually from them. And I think that's what happened in the one jewelry lawsuit, if I believe that's correct, where there was a jewelry.
I remember that case very, very, very vaguely, but I think you're exactly right here. Walt Disney still owns copyrights to later versions of Mickey Mouse. The Steamboat Willie version of the character first appeared in 1928. Disney fought tooth and nail to extend its control over the work, lobbying Congress for decades. Copyright terms were extended in 1976 and again in 1998 with the Sonny Bono Copyright Team Extension Act, which is why Disney managed to keep the short under its control for nearly a century. But on January 1st, 2024, Steamboat Willie officially entered public domain. At least that's what I thought. But there's a reason, folks. I'm playing images from the short and not actually the short itself, because Disney, well, they're fast at getting that copyright claim right there. Culture, do you have any extended thoughts before we wrap this topic up right here?
I think Morgan ultimately wins here. I think because Congress is really not wanting to get into the business of extending other things into other things. I think the courts are not interested in extending, copyright any longer than it already has been. In fact, I would argue that we need to reset copyright to 50 years, and that's it. We should also, take a cue from what it takes for a creator of an original product, especially in film and television, that they can renew their rights to owning that every X number of years. And I think that's a level of fairness that needs to be granted. And if we were to do that now, I think you'd have more creative stuff than we have now, because the people wouldn't be able to rely on this material, 90 years later, which is dumb. Those are my thoughts.
It's kind of crazy how Disney was able to secure the rights to Steamboat Willie and some of their other works, obviously, by lobbying Congress and extending these things out right here. No other company is afforded such luxury, or no other artist, I should say, is afforded such luxury. I think there is a conversation to be had about, okay, well, if these corporations outlive artists in terms of lifespan and so forth, do these laws have to be addressed again? It's an interesting argument, but this opens Pandora's box here, people, because whatever Morgan & Morgan receives when it comes to this lawsuit, whether it's, outright you've got no case here, denied, or whether or not they win, that's going to be, everybody's going to be looking at that and going, okay, what did they win on? What imagery do they want to use? How far do they go so that other people can model their works off of this specific lawsuit right here? So it's one to watch, folks. I'm telling you, this stuff is very ambiguous right now, but I think we're about to get a little bit more clarity when it comes to, well, the House of Mouse's Steamboat Willie version of Mickey Mouse.
Thanks for watching That Park Plays News. For more information, consider checking out www.thatparkplace.com. And don't forget to subscribe, share, like, and send this out on your favorite social media account.